with Lisa Peterson, Wisconsin Underwriting Counsel, and Wayne Wench, Wisconsin States Counsel from the Fidelity National Title Group, which encompasses Chicago Title, Commonwealth Land Title, and Fidelity National Title. Today's topic is alternatives to probate.
And we're going to discuss two of those today. Dwayne is going to kick us off by talking about what to do before you kick off, or what happens if you don't do what you're supposed to do before you kick off. And then I'll talk about what you can do if you're still alive to avoid probate. So our beginning topic is transfers by affidavit.
When the owner of land is a co-owner with another person who survived their death, such as a spouse or a joint tenant, of course, it's not necessary to probate their estate. All that is necessary is for the surviving spouse to record a document called termination of decedent's property interest, HT110. See, I know the number, but not the name. And it's a non-probate procedure that is very inexpensive. We're talking not about situations where there's a surviving joint tenant or spouse, but rather cases where the decedent was the sole owner of the property or was a tenant in common with another person. When someone who owns real estate dies as the sole owner, it's very important to be able to know whether there's any alternative to probate. And in the state of Wisconsin, there are some alternatives. They're not necessarily alternatives available to everybody, but they are available depending upon several factors. Number one, when the size of the estate of the decedent was less than the magic number,
50,000,
then it is possible to record in the Register of Deeds office a standard form called transfer by affidavit. It has a form number PR 1830. It's a standard form. It doesn't have to be prepared by an attorney, but it's a good idea for it to be prepared by an attorney who's familiar with the form and familiar with the laws of intestate succession. In other words, who gets your property when you die? Many people who fill out the form don't have a clue, and so they mess up filling out the form. So if you are a title agency, is it possible to give your customer some alternatives to probate? Yes, it is. You have to ask them what's the estimated size of their estate, not just the value of the real estate being transferred. What's the value of their motor vehicle? What's the value of their stamp collection? Did they have any certificates of deposit, stocks, bonds, etc.? Add them all up, throw them into the net or the basket, and if it's over 50,000, they shouldn't use this alternative. They have to go to probate court. But if the property is worth less, if all their property is worth less than $50,000, then they can file this magic form. Who is it that has to sign the form? What if Joe died? He wasn't survived by a spouse, but he had 5 adult children. Who has to sign the transfer by affidavit form? All 5, or is it musical chairs? Can you pick one? Well, generally it's musical chairs. You can pick any one. Any one of his adult children can sign the affidavit, submit it for recording the Register of Deeds. The Register of Deeds will take the recording fee, smile at them, and accept it for recording. And magically, we now have a new owner of the property. Who are the owners of the property? The answer is, when Joe died and he had 5 adult children, his 5 adult children, if he didn't have any last will and testament, share and share alike. They all became the owner of an undivided fractional 1/5 interest, that's 1/5, and they all must execute deeds by which they relinquish this interest, their respective interest, to the prospective purchaser of the real estate. So, record the record the transfer by affidavit, record the 5 deeds, warranty deeds, or perhaps quitclaim deeds, depending upon what we want after we examine the title, and the transfer of ownership will then take place. We will agree to insure the title, so long as the transfer by affidavit has 2 additional facts recited in it that the standard form PR 1830 does not contain. Number 1, did the decedent die with a last will and testament? If yes, a copy of the last will should be attached to the transfer by affidavit. And number 2, what are the names of all the last heirs of the decedent? Or if there was a will, the names of the last devisees. They have to be typed. They have to be set forth in the affidavit. So that's transfer by affidavit.
And the big thing to remember there, Dwayne, I think the takeaways from that are it has to be under $50,000 gross estate, and it's not enough just to have one of the heirs sign the transfer by affidavit. If there are multiple heirs, everybody has to join in that deed.
Well, I've taken less. Oh, yeah, the deed. Yes, exactly
deed.
Right. The affidavit form, the transfer by affidavit, can be signed by one But the deeds have to be signed by
everybody.
all. Yes.
Exactly. Okay. So now, what do you do if you're still alive and you don't want to have to deal with that? Whether or not I have $50,000 in assets, what can I do right now while I'm alive to avoid probate? There's a couple different things, but today's topic is transfer on death deeds, and you can, as a living person, record a transfer on death deed, and the State Bar does have a form for such an event. I think it's a State Bar TOD designation form that designates who you want your property to go to when you die. And when you die, what they record then is a TOD 110. We talked about the HT 110. There's a TOD 110, and that's evidence that the grantor on that TOD document, that transfer on death document, has actually died, and title is now vested in the folks that they laid out, either in the transfer on death deed or the transfer on death designation. Couple things to keep in mind with TODs. If you see multiple transfer on death documents recorded, remember that each one trumps the one that was there ahead of time. So in other words, if I do a transfer on death designation to Dwayne, and then I get mad at him because he keeps giving me these sand mine deals to work on by myself, then I decide I'm mad at Dwayne, so I'm going to record a new one, and in my new one, I'm going to give my property to Linda. Dwayne's out, Linda's in. I don't have to do anything more than that. I don't have to terminate that first TOD.
No release.
No release, no nothing. When I do it, you're out, she's in, and I don't even have to tell you. You're just out.
Right.
So that's an important thing to keep in mind. And the other important thing to keep in mind is on the title commitment. When you see a TOD on record, it does not become an exception on the title commitment. You should show it as a note, though, on the commitment, because I do think it's important to let people know it's out there so that subsequent examiners know if these folks die that there is a TOD, and we can be prepared to call for the TOD 110. But it does not become an exception. The people listed on that transfer on death deed or designation, you don't need to search their names for judgments and liens, and they don't belong anywhere in Schedule A as a vesting. It's merely a note to say, hey, should the guy in Schedule A actually die, the TOD is the method that they've chosen as an alternative to probate. Right?
Exactly.
Anything else?
No, I think the importance of recording a TOD in a timely manner before you die is really important. If you leave it in your desk drawer, the title company is going to wonder whether or not it's necessary to require probate, even though you prepared the document, you just forgot to do the important thing, recording.
Yeah, don't forget to do the important thing, record it. And that concludes our webinar on alternatives to probate. And again, the views expressed in our little seminar here are those of Dwayne Wunsch and Lisa Peterson, as represented by the Fidelity National Title Group, but not necessarily the views of the company. Have a great day.
Thank you.